Hi everyone, this is Pat Kramer, and it's May 31st, 2012. And I wanted to talk to you today about a very interesting decision that the Ohio Supreme Court came down with last week in a case called Wymsylo v. Bartec. And the case involved a constitutional challenge to the Ohio Smoke-Free Workplace Act, which you and I know better as Ohio's smoking ban. And you might recall in 2006, the voters of Ohio overwhelmingly approved via a ballot initiative this smoking ban. And since that time, it's been illegal to smoke in most indoor facilities in the state of Ohio. There are some exceptions in the law, but for the most part, as we all know now, you can't smoke indoors anywhere in Ohio. Well, there's a bar in Columbus called Zeno's Victorian Village, and Zeno's doesn't think very highly of the smoking ban. In fact, they had pretty much decided not to enforce it, and they had received some 10 violations or 10 citations for violations of the smoking ban over the years. And so Zeno's decided to mount a constitutional challenge to the law. Now, there are, generally speaking, two different types of constitutional challenges that you can make. You can make what's called a facial challenge, or you can make an as-applied challenge. And Zeno's tried to make both types of challenges. Now, the differences are that when you're making a facial challenge, you're basically saying that that law is unconstitutional in all of its applications. In other words, the law must be struck down by the courts because there are no situations in which that law could possibly be constitutional, which is a tough road to hoe, as you might imagine. The other type of challenge is the as-applied challenge, and that's the type of challenge where you're saying the law as it's written is constitutional, but as it's being applied to me, to my situation, it's unconstitutional. And that's a little bit easier of a violation to prove because you're not asking the court to strike down the entire law like you are when you're making a facial challenge. But there are some procedural differences in between an as-applied challenge and a facial challenge, and those differences ended up tripping up Zeno's here. And the biggest difference is that if you're making an as-applied challenge, you have to assert that challenge at the earliest possible moment, at the earliest possible administrative proceeding, so that you can develop a factual record for the courts. Because remember, when you're doing that as applied challenge, you're saying the law is unconstitutional as it's being applied to me, which means the facts of your particular situation are very important in determining whether or not the law is being applied to you in an unconstitutional manner. Well, Zeno's did not actually challenge any of those 10 violations that they received, or at least they didn't challenge them in the proper manner. And so what the Supreme Court said at first was, as regards to Zeno's as applied constitutional challenge, they threw it out because they said Zeno's didn't follow the proper procedure for to make an as applied constitutional challenge, because they failed to develop a sufficient record in the administrative body. So Zeno's should have appealed all of those citations and developed a record that they could have then taken to the courts, but they failed to do that. So the court basically tossed out Zeno's as applied constitutional challenge. Now, as for the facial challenge, the court said that the court rejected that challenge as well, and the court said, look, this is a valid exercise of the state's regulatory powers, or police powers as they're known. This does not constitute a taking of property, an unconstitutional taking of property under the Ohio Constitution like Zeno's had asserted, and therefore they upheld the ban. And it was a unanimous decision. It was written by Justice Judith Ann Lanzinger, and so this decision basically forever resolved the question of whether Ohio's smoking ban is constitutional. And, I think nobody's really too surprised by this decision. I think this was probably what most people would have expected. I think Zeno's arguments, while maybe you could argue that they were creative, I think they were bound to lose from the get-go. So now that doesn't mean, that being said, that doesn't mean that Zeno's couldn't make a future as-applied constitutional challenge, or some other bar could still make a constitutional as-applied challenge to the ban in the future. But what the Supreme Court here refused to do was strike down the law to entirety. In fact, the court did just the opposite. They reaffirmed that this law is in fact constitutional. So that was the case of Wymsylo v. Bartec concerning the Ohio smoking ban. So thanks for watching, and I'll see you next time.